Alright, so welcome back. So today we will analyze the conveyancing paper 2019 and have a look at the marking scheme and what the students were expected to write on. So let us have a look at conveyancing 2019 paper. So to begin with, I will read through the question and give you the marking scheme as it was outlined during that year. So question 1, we have been told that Jane is the registered proprietor of two properties valued at 40 million Kenya shillings and charged at Huduma Bank for a loan facility of 10 million and title number Nairobi Block 140 valued at 20 million. So she, together with her husband and 3 children, live in the mansion erected on land parcel 209, while the other property is currently let to monthly tenants. So Jane approaches her financial Huduma for a further advance to enable her restock her business. The bank, however, declines her request, citing high cost of lending brought about by capping of interest rates. Feeling disappointed, she walks into Marafiki Bank and the bank offers her a loan facility of 30 million Kenya shillings. So Marafiki is agreeable to sharing the security charged at Huduma among other securities which Jane will offer the institution. Marafiki quickly issues you with instructions to carry out the security perfection. Let me keep the meeting open so that other members can join along the way and find this discussion to be ongoing. Okay, so back to business. Marafiki quickly issues you with the instructions to carry out the security perfection. So basically this question is testing on security perfection, and let us see what the question further required when it comes to question A, B, all the way to E. Question A, identify any 2 specific securities that Marafiki may take as collateral for the advance to June to Max. Noting to identify the name of the shared security, advise your client on the nature and legal implications of such a security and any remedy which the lender may adopt while taking the security. C. Identify and explain 5 basic requirements or contents of a charge document that would, in their absence, invalidate the security. Following the recent ruling declaring capping of interest rates unconstitutional, Marafiki revises their interest rates upwards from 13% to 24%. Jane's loans fall into arrears amongst many other borrowers. The loan recovery manager forwards her file for review and advice on how the bank can sell the property without exposure to claims. 5 marks. E. In the recovery process, the bank realizes that Jane colluded with her neighbor and registered cautions on the 2 properties, citing an undisclosed rights over the land. Advise the bank on the validity of the caution and how they can go about removing it. Okay. Advise the bank. Note that the bank was unaware all through. This is a technical question that requires a multifaceted approach to how a student will apply the knowledge that they have deeply gained. So question A, 2 specific securities Marafiki may take. So Marafiki can take at least these 2. They can take a second charge over title number Nairobi Block 140, provided it is an encumbered immovable property. Then they can also take a further charge, or what we call a second or subsequent charge, or a pari passu charge over land number 209 that has been already charged to Huduma, but it must have Huduma's consent. Okay, so for further charges, you must obtain the consent of the previous charges. So charge is the bank, charge is the individual taking the loan. So B, shared security, nature, legal implications, and lender remedy. So if you read question B, noting to identify the name of the shared security, advise your client on the nature and legal implications of such a security and any remedy which the lender may adopt while taking the security. So what is the name? The name is a shared security, is a pari passu charge or equivalent shared ranking security over a land number 209, also known as a second charge or a further charge. That is the name. So the question carried 5 marks. So what are the other angles for you to scoop the rest of the marks? You have identified the name of the shared security to be a further charge or subsequent charge. Then you have to advise your client on the nature and legal implications of such a security and any remedy which the lender may adopt while taking the security. So it means huduma and marafiki rank equally against the same charged land and must coordinate for enforcement. The examiner expects to see the governing rules that informed the candidate's choice when it comes to question B. If you look at section 53 of the Land Registration Act, second or subsequent charges require consent of the first chargee. Okay, so chargee will be the one issuing the loans or the bank. The second governing rule, section 82 of the Land Act, also known as tacking or priority for further advances, is controlled and depends on registration note or subsequent charges written consent. Okay, tacking has been allowed pursuant to section 82 of the Land Act, and section 53 of the LRA is the enabling provision that says you should obtain consent of the first chargee. If charges rank pari passu, the transfer on sale must include consent of the pari passu chargee. Okay, section 98(7) of the Land Act. What are the legal implications? Because the question has also told you to analyze the legal implications of the name pari passu charge. Legal implication is that equal ranking. Neither lender has priority over the other on that land. Recoveries from sale proceeds are shared by the intercreditor or pari passu terms. 2. Enforcement coordination. Because section 98(2) of the Land Act provides that a selling chargee must secure the other pari passu chargee's consent in the transfer instrument. Otherwise, closing or making the other chargee to have registration risk. So section 98(7) of the Land Act must include consent of the pari passu chargee. Documentation must be tight. You need a deed of priority, intercreditor deed setting out enforcement lead, notices, application of proceeds, standstill, and cure rights. Okay, so those are the legal implications on explaining the nature of this setup, this charge setup. So the question also wanted you to say the remedy, because it was a multifaceted based question. You have identified the name of the shared security, advised your client on the nature and legal implications of such a security and any remedy which the lender may adopt while taking the security. So the total marks that were awarded were amounting to 5. So something. Stay in the call. So let us look at the remedies so that we can scoop all the 5 marks. So remedy, the lender should adopt while taking the security. So before perfection, insist on 1. Written consent by huduma to creation of the charge ranking security or to a second or subsequent charge pursuant to section 57 of the LRA. Intercreditor deed of priority, pari passu agreement allocating who enforces, how notices are issued, how proceeds are applied, and mutual consent for sale or transfer, because this aligns with section 98(7) of the Land Act. Okay, so those are the remedy the lender should adopt while taking the security. Who enforces, how notices are issued, how proceeds are applied, and the mutual consent. Question C. Identify and explain any 5 basic requirements or contents of a charge document that would, in their absence, invalidate the security. So 5 charge document requirements whose absence can invalidate the security if the charge instrument fails to identify the parties, the land, secured obligation, execution or attestation, or registration mechanics. It is vulnerable as an unenforceable registrable security. Minimum essentials. 1. Correct identification of the parties and their capacity. Full names, ID, PIN numbers. Charger must be the registered proprietor. Chargee properly described. 2. Clear description of the charged property. Give the title number, the acreage, register section, touch the title, list particulars to avoid uncertainty. 3. The secured obligations and amount, the principal plus facility terms, principal sum, interest basis, repayment, events of default, what exactly is being secured, including all monies or further advances if intended. So basically that is the secured obligations and amount part. Proper execution and statutory attestation. Signatures by charger or the chargee, attestation by an advocate or commissioner as required for registrable instruments, where we see that if it is defective, execution risks non-registration and enforcement. 5. Spousal consent where applicable, matrimonial home risk. Since the family resides on LR 209, treat it as a matrimonial home risk. Missing spousal consent exposes the charge to challenge and injunctive relief risk. There is a reason why the examiner told you that the family were currently residing in LRA number in land registration number 209-1030. So many students could have omitted a spousal consent in such situations. Power of sale or remedies clause aligned to the statute must not contradict statutory notice and duty regime. Omission or contradiction creates enforcement vulnerability. Then registration particulars. Instrument must be in registrable form. Include presentation for registration, and registered interest generally won't bind third parties as legal charges. Okay. Now let us read question D. Following a recent ruling declaring capping of interest rates unconstitutional, Marafiki revises the interest rates upwards from 13% to 24%. Gents loans falls into arrears amongst many other borrowers. The loan recovery manager forwards a file for review and advice on how the bank can sell the property without exposure to claims. 5 marks. So the examiner expects you to have mastered the procedure to be followed for exercising statutory power of sale. So Marafiki should only sell by strictly complying with the Land Act, notice regime, and the statutory duty of care on valuation or price most successful borrower claims, attack notices, and undervaluation. Governing rules. Pursuant to Section 90 of the Land Act, there must be a default notice. Okay, in this default notice, you must outline the minimum content plus minimum 3 months to rectify where money is in default. So the first notice goes for 3 months. Pursuant to Section 90, this notice is known as a default notice. Then you have the second notice, known as notice to sell. This is provided for under Section 96 of the Land Act, and it gives 40 days. Okay, it is issued 40 days after service before completion of the contract. Okay, so once you have been served with a notice to sell, you are given 40 days after service before completion of the contract. Section 96 of the Land Act. Then you have Section 97 of the Land Act that says that duty of care to obtain best price plus mandatory first sale valuation before the sale. So you have an obligation arising, okay, because you have been told to advise the client on how they will sell the property without exposure to claims. Section 97. You have sale mechanics plus advertising plus valuation. Age 6 months for private contract plus pari passu consent in transfer. Section 98 of the Land Act. Then protection of purchaser or borrower's remedy, generally damages absent a fraud or dishonesty. Section 99. So remember, these are merely mere statements on governing rules that a student ought to have read through before answering this question. Okay, what are some of the judicial interpretation and what courts usually enforce? So courts restrain sales where first sale valuation is missing or is outdated or notices are defective, but they generally allow sale where notices plus valuation compliance is proved. Okay, so CW Hotels and Resorts Investment Company versus KCB Bank, where the Court of Appeal upheld sale steps where Section 97(2) on valuation compliance was shown. Mere valuation differences are not enough without showing incompetence or irrelevant factors. Okay, we saw another decision, Petiro Ngwacho versus KCB. Injunction failed where statutory notices plus valuation were evidenced. So, in a brief summary, how could you have answered question D to prevent an exposure? So, serve a compliant Section 90 notice on Jane being the charger, spouse who consented, and any person required under Section 96(3). Later, stating default nature, amount, and giving 3 months to rectify. Okay, so you serve the first notice, then you serve the other notice. Okay, after 3 months, that is, then you give another notice for giving them time to rectify, 30 days. After expiry of Section 90 period, serve Section 96 notice to sell and wait 40 days before completing a sale contract. 4. Obtain a fresh first sale valuation from a qualified valuer immediately before sale steps. Ensure sale price is defensible under Section 97. Best price reasonably obtainable to preserve the duty that we saw above. Choose the sale method and comply with Section 98. Are you going for public auction? Then observe proper advertising and reserve price, or is it a private treaty? Ensure valuation report is below 6 months old for private treaty. If the land number 209 is pari passu, ensure pari passu chargee consent is included in the transfer. This is provided for under section 98(7) to avoid registration failure. So I believe up to that point I have duly answered what the examiner expected of a student so that he can scoop the 5 marks. Then E. In the recovery process, the bank realizes that Jane colluded with her neighbor and registered cautions on the two properties, citing an undisclosed rights over the land. Advise the bank on the validity of the caution and how they can go about removing it. Note that the bank was unaware all through. How did the marking scheme interpret this part? Caution's validity and removal, where bank was unaware, the caution carried 3 marks. So a caution is only valid if the cautioner fits the statutory categories, e.g. claims registrable interest. If the cautions are collusive or without a genuine registratable claim, the bank should apply for removal via the registrar's notice, process or court and pursue wrongful caution consequences. Governing rules. Section 71 of the Land Registration Act provides that who may lodge a caution must claim a right to obtain an interest, license or bankruptcy application. Okay. Section 71 provides for people who may lodge a caution, and these people should have a right to obtain an interest, a license or bankruptcy application from that which is being registered. Effect. Inconsistent dispositions won't be registered unless consent or order. Section 72 of the Land Registration Act. Removal by cautioneer, registrar after notice, or court, and special rule removing post-charge cautions after charging sale transfer. So in effect, we are being told that Section 72 provides for the people or the steps that can be taken for removal of the caution. It can be done by the cautioneer, the one who registered the same. It can be done by the registrar after notice or court, and special rule removing post-charge cautions after chargee a sale transfer. What Marafiki should do. Now this is where you are answering the question. Demand particulars or evidence of the undisclosed rights to test if it is a claim to a registrable interest under Section 71, then apply to the land registrar for removal under Section 73(2). So you have the particulars, then you apply to the land registrar for removal. Registrar issues notice to the cautioneer. Registrar will issue a notice to the person who registered this caution. If no objection, caution is removed. If objection, registrar hears parties and rules under Section 73(4). Okay. If urgency or obstruction persist, move to court for an order removing the caution. This is also available under Section 73(1) of the Land Registration Act. Post-sale. If sale proceeds and transfer by chargee is registered, note that Section 73(5) provides that the registrar must remove any caution registered after the charge that purports to block chargee dealings after 30 days from registration of the transfer. Okay. what are the key risks and steps that you must note? Confirm whether Marafiki's sharing is pari passu or second charge. Draft the correct intercreditor or priority and secure Huduma's consent up front. Person 2. Section 57 of the LRA and Section 98(7) of the Land Act. For recovery, treat notices plus valuation as non-negotiable. That is where borrower injunctions succeed or fail. That was a mandatory question, and the mandatory question was a bit technical because it has tested various angles when it comes to the application on charge, registration on charge instruments, the powers of the registrar, land registrar when it comes to charge instruments, how the same rank in priority, the legal consequences of not complying with various statutory provisions on charges. Those were tested in question number 1. Question number 2. Paul resides in the UK. He had contracted his cousin Peter to assist him scout for a house to purchase. Peter recently sent Paul photos of a villa on offer for sale by Mvuli Limited, the vendor. The property is in Karen, occupying a quarter-acre of land. He settles on purchasing the property and requested to see the agreement for the sale before committing on any payments. Peter thus forwarded a copy of an agreement for sale drawn by the vendor's estate agent with terms that the purchase price was 70 million, all payable upon execution of the agreement or within 14 days thereafter, failure to which the property is released back to the market. Paul is apprehensive of losing the property. Immediately wires the funds to the vendor, whose account details were indicated in the agreement. 6 months later, Paul is yet to hear from neither the vendor nor his cousin. Efforts to reach the renowned estate agent were unsuccessful. On his return to the country, he visits your chambers seeking legal intervention. 1. In detail, advise Paul on the necessary steps that any purchaser must take before entering into a sale transaction. B. Identify and advise your client on all the formalities necessary in giving legal validity on any land transaction in Kenya. Okay, so steps a prudent purchaser must take before entering a land sale transaction. 1. Paul should not have wired the full price on execution of 14 days without verification. A purchaser must verify title, seller capacity and authority, encumbrances, and structure payment through stakeholder protections. Governing rules. A contract for sale of land must be in writing, signed by all the parties, and each signature attested to pursuant to Section 38 of the Land Act. How have courts interpreted this part? Non-compliance with the writing and signature attestation requirements is commonly fatal to enforcement, e.g. specific performance. Practical steps. What Paul should have done. Paul should have conducted due diligence on the property and title. Official search at the relevant land registry. Confirm registered proprietor, the tenure, the acreage, restriction, cautions, charges, caveats and easements. Then verify survey identity. Check the beacons and whether any rate or rent arrears still exists with the county or Ministry of Lands as applicable. Then 2. Due diligence on the seller, Mvuli Limited and the agent. Okay, so you have conducted due diligence on the property and the title. Then in the due diligence of the property and the title, you have visited the relevant land registry. You have even verified the survey identification documents of this parcel. Then you have gone further to do due diligence on the seller himself, Mvuli Limited, and the agent. Confirm vendor's corporate status and authority to sell. Do you have any board resolutions or authority? And confirm the agent's mandate. Do you have written agency or letter of instruction? Secondly, confirm that the bank account is genuinely the vendor's, not agent's account or spoofed details. Best practice is stakeholder or an escrow account. Then, transaction structuring. Use a stakeholder advocate arrangement. Deposit typically 10% held by advocate as stakeholders. Balance release on completion against deliverables. 2. Insert protective conditions precedent. Satisfactory such as valid completion documents, tax compliance, consents if any, vacant possession, and tenancy position. So Paul did not conduct due diligence when it comes to the transaction structuring model that he was to use. Completion planning. Confirm completion documents list, timelines, completion venue, and registration plan. Who lodges transfer, who pays stamp duty, and who collects the title. So that wanted how many marks? 4 marks. Question B. Identify and advise your client on all the formalities necessary in giving legal validity on any land transaction in Kenya. Formalities necessary for legal validity of land transactions in Kenya. Legal validity typically requires a compliant written contract, proper execution and attestation, any required statutory consents, stamping and registration to pass legal title. Governing rules. Validity of contract for sale of land must be in writing, signed and attested to pursuant to Section 38 of the Land Act. Execution formalities for registrable instruments including corporate execution and execution outside Kenya. So we have execution formalities for registrable instruments including corporate execution and execution outside Kenya, because Paul was outside the country. 3. Registration principle. Disposition does not operate to transfer or create interest until registered, okay, subject to stated exceptions provided under Section 43 of the LRA. Stamping prerequisite to registration provided for under Section 46 of the LRA. Then you have 5. Land Control Board consent for control, LCB board consent and control transactions in agricultural land within land control areas, if applicable, plus 6-month timeline. This is pursuant to Section 6 of the Land Control Act and Section 8 of the Land Control Act. Courts interpretations. Courts regularly refuse to enforce signed agreements that do not satisfy the mandatory writing or signature attestation threshold. Hello? Hello? Amego missing. Amego missing walai. Amenyamaza, amesema ata get back. Walai. Yes. Haikuangi online. True. Hapo italemea mtu. Kai. True. Atoe pesa. Ina make sense. Yeah. Atoe 15. True, ina make sense hivyo. Na ni wengi, nakaa ni wengi. Yaani hiyo students pia kushikwa hivyo. Wenye students pia wanashikwa, inakaa pia kuna mawakili wanatargeting students. Juu ni wengi. Ndio kuna wengine. Kuna makesi mingi huko shule. Unawachuka. Yes. Oh yeah, true. Hiyo itakuwa viable. Yes. True, hata jua. Ni ukweli. Gai. Sawa wakili, shukran. Haya. So before I took up a call, I was on the interpretation by the court on various aspects. So where there is no compliant sale agreement, the claim collapses, as was seen in Omboya versus Zoom Zoom Investments Limited. Then have I unmuted? Let me check. Oh yes, now I've unmuted. Welcome, Mr. Chedwick Odhiambo. So when you are still analyzing, we were analyzing question 2 on part B on identification and an advisory opinion to your client on all the formalities necessary in giving legal validity on any land transaction in Kenya. So I was emphasizing on the relevant provisions that a student ought to have known before giving this legal advice, because the question carried 6 marks. So a student ought to have known on the essentials of a contract when it comes to immovable property being in writing, signed and attested to. You ought to have known about the registration principle, that until the land is registered, that's where an interest is created. Then you ought to also have known on land control board consents, or where there are matrimonial spouses consents as to be crucial. Now these are the formalities on 6 items the student ought to have scored with. 1. Written agreement capturing all essential terms, property price, completion, conditions, default and stakeholder terms, pursuant to section 38 on the Land Act. 2. Signatures of all parties or duly authorized agents, section 38 of the Land Act. Then attestation and witnessing of each signature, pursuant to section 38 of the Land Act, and ensure the witness is identifiable. 4. Proper execution requirements for registrable instruments. Company execution, if signed abroad, do you have notarial certification or endorsement? Because in this situation, Paul was abroad, but the company purporting to sell the land is based in Kenya. We have not been told that the company has any board resolution, has any authority to sell this land. So Paul omitted to observe a critical aspect on execution requirements pursuant to section 44 of the LRA. Then Paul failed to check all required statutory consents, notably land control board consent if the land is in agricultural area zone, in a land control area, and apply within 6 months, pursuant to section 6 and 8 of the Land Control Act. Then stamp duty assessment or payment and stamping before registration, plus registration of the transfer lease chargee to pass legal interest. We have seen section 46 and 43 of the Land Registration Act being an authority to in stating that stamp duties must be paid before registration of any parcel of land, so that a legal interest can pass with a clean title. Okay, so let us look at question 3. In question 3, I decided to go deeper because professional undertakings are both questions emanating from the professional ethics unit and also from the conveyancing unit. So I took a deeper dive when it came to professional undertaking. I even went to analyze the various scenarios that a student ought to know. I even analyzed situations where students are confused. So question 3, you act for Musa, who is selling his property Kiasi Chale 103 to Waridi. Waridi has taken a loan for the purchase from XYZ Bank Limited, who are financing the transaction for 10 million Kenyan shillings. You are ready to complete the transaction by handing over the title document to the bank advocates, who will register the transfer to Waridi and charge to XYZ Bank together. So the bank's advocates have issued a PU to you for the payment of 10 million, but upon review, you find it unsatisfactory. Discuss the critical components that should be contained in the PU in this instance, and the question demanded 5 marks. Then question B, draft a suitable professional undertaking in the form and content that you will now require from the bank's advocates. So I decided by answering question A that you should only release Musa's completion documents against an undertaking that is clear, unconditional, save for objectively verifiable completion events, time-bound, and tied to registration outcomes with an express irrevocability and personal liability of the bank's advocates. Those are opening statements I have not yet answered. So if you look at the governing rules, enforcement of an advocate's undertaking is by the High Court pursuant to Order 52, Rule 7 of the Civil Procedure Rules. Judicial interpretation. What makes it unenforceable? Undertaking must be clear, unequivocal, and enforceable against the advocate in his personal capacity. View the case of Karaoke versus Bill, Simba, and Associates Advocates. Then, conditional or uncertain undertakings, e.g., upon receipt of funds or no fixed dates or triggers may fail enforcement. If you read the case of Njeru Nyaga and Company Advocates versus Njeri Mboro trading as Njeri Mboro and Company Advocate 2020. Components you should insist on tailored to this completion. Parties plus transaction identification, Musa being the vendor and Waridi being the purchaser. The property name is Kiasi Chale 103. What is the purchase price, bank finance amount, and bank advocates firm details. Okay, so those are the components that you should expect to be clearly explained to you in the PU that you are going to receive or to issue. Consideration for undertaking, what you will release. List the specific completion documents you will deliver, original title or executed transfer, land rate or rates clearances if held, and completion documents a schedule. Then have a clear payment obligation plus a fixed timeline. Irrevocable promise to pay 10 million to your client account within X days of 1. Registration of transfer or charge, or presentation for registration. Pick one clean trigger. Okay, so in essence, the payment obligation should have something tied to it on a fixed timeline that triggers one to say that upon default of this payment, I can foresee a situation where I had inserted a certain timeline for you to comply with, so that we can say that the PU is very clear to the terms that were indicated, and in any event not later than a stated long stop date. The other point that a student ought to note is that objective trigger events plus proof. Define deliverables the bank advocates must provide to evidence trigger, official search or title indicating registration or presentation of receipts. So have an objective trigger event and approve. Is it an official search that now indicates the name has been registered or the title deed is duly registered? They send you a copy. Okay. And conditionality. No subject to receipt from client or bank. Payments must not be contingent on the advocate receiving funds or client approval. Courts treat that as unequivocal. So never say that I'm expecting. If you see an examiner using the word, the advocate is expecting to receive funds from a client or upon the client's approval, this means that This PU is not a conditional, okay, and conditionality, not subject to receipt from client or bank. Stakeholder handling of documents. Confirmed documents are held strictly as stakeholders for registration of transfer to Waridi and charged to XYZ only. No release to borrower without registration. Okay. 7. Return or indemnity mechanics on failure. If registration fails or aborts, advocates to return all documents within X days and not lodge further instruments. If documents are lost, an indemnity and replacement at cost clause. Okay, so if any registration fails, do you have that return or indemnity mechanics upon the failure? Interest and cost on default. Provide that sums unpaid after due date attract interest and cost of enforcement. Then you have the personal liability and enforceability provision. Expressly state that it is a professional undertaking by the advocates in their professional capacity and it is enforceable under Order 52, Rule 7. The question also expected a student to draft a typical suitable professional undertaking. So in this situation, many students panicked because they thought that there is a standard format of doing the same, but the CLE is not basically testing on that. It is testing on the contents. So you have the title, professional undertaking, the date, to who, for Musa being the vendor, our ref and your ref, then the title, sale of property, parcel number, undertaking to pay 10 million. Okay, it is certain from the word go. We, advocates acting for XYZ Bank Limited, in the above transaction and in our professional capacity as advocates, so that is a mark. You have already stated that you are acting in your professional capacity as advocates, hereby irrevocably and unconditionally undertake to you as follows. 1. Consideration of documents to be released. In consideration of your releasing to us the completion documents listed in the schedule below, collectively the completion documents. Now you see you are certain, you have even annexed proof of the documents that you want that you intend to form the completion documents. For purposes only of registration of the transfer to Waridi and the charge in favor of the bank, we undertake to pay as set out below. 2. Payment undertaking. We shall pay to you the sum of Kenya shillings 10 million being the bank's financing portion of the purchase price by RTGS or telegraphic transfer to your client account. This is the client account, you insert the details. So we have not been told that they will be waiting for client's approval or upon receipt of the fund. Okay. 3. Payment trigger and timeline. Payment shall be made within 3 working days of the earlier of 1. Registration of the transfer of the property to Waridi and registration of the charge in favor of the bank. Okay, or receipt by us of the duly issued presentation or booklet receipts evidencing lodgement for registration of the transfer and charge, and in any event not later than 14 days from the date we receive the completion documents. Okay, so we have payment triggers and strict timelines that now upon breach we can execute, we can enforce. Stakeholder custody or use of documents. We shall hold the completion documents strictly as stakeholders and shall use them only for 1. Payment of stamp duty and registration of transfer or charge, and 2. Procurement of registration outputs. We shall not release the original title or any registrable instrument to Waridi or any third party prior to registration. Then you have failure to complete and return of documents. If registration is rejected or the transaction otherwise fails to complete for any reason, we shall, within 7 days of such event, on your demand, whichever is earlier, return to you all completion documents in the same condition as received, and shall not lodge or maintain any dealing against the title without your written consent. Then you have the default clause. Any sum unpaid when due this undertaking shall attract interest at court rates from the date until payment in full, and we shall pay your reasonable cost of enforcement. Then 7. Nature of undertaking. This is a professional undertaking given by us personally as advocates and is enforceable against us in accordance with Order 52 Rule 7 of the Civil Procedure Rules. Yours faithfully, give the names and the particulars of the person who is signing, and because we mentioned a schedule of completion documents, you can list them to form part of the list of schedule. So I decided to state the scenarios where a professional undertaking can be given. So scenario number 1, where there is a release of original title, transfer or charge documents to another advocate pending payment of purchase price or loan balance. In this case, this formed our scenario. 2, stakeholder holding of deposit, e.g. 10%, and undertaking to release it upon completion or refund upon rescission. That is another scenario where a PU can be issued. Another scenario, undertaking to discharge an existing charge. Purchasers or bank advocates pay redemption sum against undertaking by sellers or bank's advocates to register discharge and release title. Okay, so we can say another part where PUs are used is undertaking to discharge an existing charge. An examiner can use that scenario. 4, undertaking to pay stamp duty or registration fees and to register instruments and return registration outputs within a stated timelines. That is also another scenario. Undertaking to remit sale proceeds to a third party, e.g. settlement of vendors' existing loan, payment of capital gains tax rates arrears out of completion monies. Then we have litigation or security, undertaking to hold a specified sum as security pending determination and release upon occurrence of a defined outcome commonly enforced, as it was applied in Ishmael Nyasimi and Charles Mithieka versus David Onchangu 2018. Most student confusion is about 1, whether a letter is a professional undertaking at all, or 2, whether it is enforceable if conditional or unclear, 3, who can enforce it and by what procedure, and what happens when the undertaking, conveyance collapses or fraud intervenes. So below are scenarios and the correct answers to the scenarios. So governing rules, we see Order 52 Rule 7 of the Civil Procedure Rule. There is a landmark decision that I have outlined in every scenario that requires a clarification. Okay, so we start with 1. Undertaking must be clear, unequivocal, and capable of performance, and an advocate is personally bound. Equip Agencies Limited versus Credit Bank Limited 207. The court held that a professional undertaking given by a firm of advocate is enforceable under Order 52, Rule 7 of the Civil Procedure Rules. The undertaking in the question was clear, unequivocal, and relied upon by the applicant, who fulfilled their part by releasing the title documents. The respondent firm benefited from the undertaking and failed to pay the outstanding tax cost within the stipulated period. The court found no vitiating factors to discharge the undertaking and determined that the respondent firm is liable to honor its professional obligation. The court emphasized that such undertakings are essential for the smooth functioning of legal practice. Okay, and the same, if breached, will also amount to a professional misconduct. So that is rule number 1. Undertaking must be clear and equivocal and capable of performance, and the advocate is personally bound. 2. Undertakings that are dependent on receipt of money from third parties or uncertain dates may fail as undertakings. Jeru, Nyaga and Company, Advocates versus Njeri Mburu 2020 decision. The genesis of this dispute is a letter dated 19th March 2019, authored by the defendant herein and addressed to the plaintiff. It is important to cite the entire letter in this ruling because it is the contents that will eventually determine this matter. Okay, so in fact, this also forms part of examination situations. You can be pasted for a letter before you by the examiner, so it is important we go through this letter so that we extract out the test that we can use. Michael Kariuki Wanjohi. We refer to a letter dated 4th March 2019 from the above gentleman and confirm that he has instructed us to pay to yourselves the sum of 19.2 million on account of Njoroge and Wamboi. Full particulars are unknown to us. Okay, we wish to confirm that our client owes the above gentleman amounts in excess of 19.2 million whose payment date cannot be ascertained. Part of the debt has been paid in the past and your payment will be discounted from the outstanding balance. As instructed, we confirm that any amount received in the future on account of the above gentleman shall be forwarded to you. However, we reiterate that we are also pursuing the third parties for the payment and due date of the payment is not known. We therefore urge for patience. Yours faithfully, signed by Njeru, Mburu and Company Advocates. Apparently, a sum of 8 million was remitted because on 18th September 2019, the plaintiff wrote to the defendant in the following terms: Dear Madam, debt of 19 million owed to our client by Michael Kariuki Wanjohi. We refer to your letter of undertaking dated 19th March 2019 and acknowledge receipt of 8 million. Please remit the balance by the end of the month as promised through care of Michael Kariuki Wanjohi. Yours faithfully, Njeri Nyaga and Company Advocates. The same was signed by M.N. Nyaga. It will appear this letter was not acted upon, resulting to the filing of this suit. There is no doubt that this court has jurisdiction to enforce an undertaking given by an advocate as clearly provided for in Order 52 Rule 7 of the Civil Procedure Rules and Section 14 of the Advocate's Professional Conduct Regulations. Ratio decidendi. The court found that the letter dated 19th March 2019 did not constitute a professional undertaking as defined by law. The letter was not an unequivocal promise to pay the sum claimed. Rather, it was conditional and dependent on the receipt of funds from third parties. With the repayment date being uncertain, the court emphasized that for an advocate's professional undertaking to be enforceable, it must be clear and conditional and not subject to further contingencies. Since the letter contained several conditions and vague promises, it could not be enforced as a professional undertaking. Consequently, the defendant could not be held liable for the indebtedness of their client to the plaintiff's client based on the letter relied upon. The other test: if undertaking is conditional, the beneficiary must prove the condition occurred. If not, enforcement fails. Okay? Malik and Company Advocates versus Fred Mutua, 2014. In this situation, I decided to highlight the applicant's argument and the respondent's argument, then narrow down to the ratio decidendi. So the applicant's argument was that the plaintiff contends that the defendant, having adopted the professional undertaking originally given by the late Mr. Kisebu, is bound to pay the sum of 3098 USD upon completion of the sale of the property. The plaintiff asserts that the undertaking was clear, unequivocal, and binding, and that the defendant's letter of 17th November 2011 constitutes an irrevocable adoption of the undertaking. The plaintiff seeks enforcement of the undertaking and payment of the stated sums plus interest. The respondent's argument were that the defendant argues that the undertaking was conditional upon completion of the sale of the property, which has not occurred. The defendant further submits that the sale is the subject of ongoing litigation in that case number and that the suit is premature and malicious as the property has not been transferred. The defendant also contends that the undertaking lacks enforceable conditionality and that no evidence of completion or registration of conveyance has been provided. The ratio decidendi. The court found that while the defendant had adopted the professional undertaking originally given by the late Mr. Kisebu, the undertaking was expressly conditional upon completion of the sale of the property. The plaintiff failed to provide evidence that the sale had been completed or that the conveyance had been registered. The sale agreement itself was not produced before the court, and there was no proof that the condition precedent for payment under the undertaking had been satisfied. Accordingly, the court held that the plaintiff was not entitled to enforcement of the undertaking or payment of the claimed sum and dismissed the originating summons with cost to the defendant. So that is the rule of the thumb that we have extracted, that the beneficiary must prove the condition duly occurred. A stated figure may just be an upper limit, not a condition that the whole amount must be advanced. This is another case law. Harriet Sheth, trading as Harriet Sheth Advocate versus K.H. Osmond, okay, 2011, ratio decidendi. The Court of Appeal held that the respondent's professional undertaking was not conditional upon the full 25 million shillings being advanced to Banita Sisal Estate Limited. The 25 million figure merely set an upper limit of liability, and the respondent was liable for the amount actually advanced and unpaid. The court found that the originating summons was not fatally defective, as any procedural irregularities did not prejudice the respondent who had responded to the summons and participated in the proceedings. The court emphasized that a professional undertaking by an advocate is a solemn obligation, and the advocate is required to honor it regardless of any perceived hardship, with recourse available against their own client only after fulfilling the undertaking. The appeal was allowed. The High Court's order dismissing the OS was set aside, and the respondent was ordered to honor the PU within 30 days, failing which enforcement could proceed. Okay, so a stated figure may be just an upper limit, not a condition that the whole amount must be advanced. You can be told to comply with the amount that is due. Maybe in the first installment, you can be told first to settle the first installment as you await to pay the rest. So use the correct procedure. Suing in an ordinary plaint can be fatal or detrimental to your client. Langata Gardens Company Limited versus June Kathini Mutisia and two others, 2013 decision. The court found that the plaintiff's suit against the second defendant was for enforcement of an advocate's professional undertaking, which is governed by the mandatory procedure set out in Order 52 Rule 7 of the Civil Procedure Rules. The plaintiff failed to comply with this procedure by not instituting the claim by originating summons as required. Consequently, the interlocutory judgment entered against the second defendant was in contravention of mandatory legal provisions and was therefore a nullity. Furthermore, the second defendant's preliminary objection, which challenged the court's jurisdiction, should have been determined before any interlocutory judgment was entered. That was an obiter. So, but the key thing that I want you to extract is that whenever you have been told by the examiner to proceed and give recourse to a certain client who wants to enforce a professional undertaking against an advocate, and you duly proceed and use a wrong format, we can say that that cannot be cured under a technicality. That is not a technicality, because the law is very clear on mandatory procedure set out in Order 52 Rule 7. And maybe the marking scheme will read that if a student has used any other document apart from a originating summon, you will fail that question. Confusing scenarios and the correct answers. We shall pay you once our client sends us funds or upon receipt of funds. Answer: usually not an enforceable professional undertaking. This is too uncertain, too contingent. Draft must avoid subject to receipt. If you ever see that, that is a marking scheme. 2. We undertake to pay 10 million within 7 days of completion, but completion is disputed. Answer: it is conditional. Beneficiary must prove completion occurred as defined in the documents. If not proved, enforcement fails. Undertaking says up to 25 million and only 12 million was actually advanced. Answer: advocate is liable up to the amount actually advanced. The 25 million is a cap, not a condition that full 25 million must be advanced. Okay? So the advocate is liable up to the amount that has been actually advanced. So the 25 million is merely a cap and not a condition that full 25 million must be advanced. 4. The advocate argues I gave the undertaking on instructions. My client failed to pay. I intend to sue the client. This is wrong. Undertaking is personal to the advocate and the law firm. Client disputes are irrelevant to enforcement. Equip Agencies versus Credit Bank 207. The beneficiary files an ordinary suit or plaint for breach of undertaking. Answer: procedurally vulnerable. Correct route is originating summons under Order 52, Rule 7, as we have seen in Langata Gardens decision. Undertaking not addressed to the claimant advocate. It is a copy to all concerned email. Risky. May fail for lack of clear promise to a specific beneficiary. Fix by insisting it is addressed to you, identifies transaction and is unequivocal. Courts enforce clarity and specificity. It should be clear and unequivocal. 7. Undertaking is signed for the firm, but by an advocate staff member. High risk. A professional undertaking must be given by an advocate or firm in professional capacity. Insist on advocate signature and firm stamp. But if a staff member of the law firm continues and duly issues out the undertaking in his line of duty, then the undertaking will bind the firm. 8. Undertaking mixes obligations, will register, transfer or charge and pay you when the title comes out. Too many moving parts. Students miss that this can create open-ended timelines. Correct approach, include a long stop date and define what happens if registry delays or rejection occurs. Okay, underlying transaction collapses due to fraud. Giver says undertaking is discharged. Answer: not automatic. Court looks at the wording. If payment was conditional on completion and completion never happened, enforcement may fail. If unconditional, advocate remains bound. 10. Undertaking is for release of title but does not describe which title or parcel. Answer: this is uncertain. It exposes you to an enforcement risk. Must identify parcel number or the title number and documents being released as we duly drafted. So how to answer in such situations in an exam? Ask yourself, is it a professional undertaking? Is it clear? Is it unequivocal? Is it a personal promise? 2. Is it conditional? If yes, has the condition been satisfied? 3. Correct enforcement route. Do you know of the OS? Defenses. 4. Defenses that fail. Client did pay. I did not have any instructions. Cite Equip Agencies and the general principle. So from where I am, there is a lot of background noise. So for this session, I'll have to partition it into two sessions because I'm somewhere in a country. So I thank you for your participation, and I beg to stop the recording, and I will duly resume because we have only been left with question 4. Then do trial advocacy together with LPM, because I saw that with LPM and trial advocacy we can easily read through it using past papers, because there is no defined notes to the same, but through questions we will analyze a lot and in a summary manner. That's why I've decided to incorporate the same to our sessions. So once we resume, we'll make sure that we have finalized on this paper, because I hear the background noise inaongezeka. So Mr. Chedu, thank you, and Mr. Moraro, I greatly appreciate for your attendance. So let me end. Then resume. Initially I usually go to an office, but leo sikuenda. So thank you guys. Unless anyone has a comment, any area to improve.
Okay, apologies, I did attend late. I do apologize for that. I'm actually still in the office as well, so I do appreciate the discussion that we had today. I don't know, perhaps if is it possible to get maybe the document you're using, or maybe next time you can just share the screen so that we can able to follow through as well, to also capture and see through. Thank you.
Apologies. Unajua nilikuwa nadhani nimeshare.
No, we are not
Poleni.
sharing it, so we are just listening and trying to grasp whatever we could get.
Poleni. Uzuri luckily,
Yeah.
I am double recording. So
Okay.
whatever I'm going to upload,
Yeah.
iko na hiyo screen visible. So
Okay.
naiweka YouTube and I'll duly share
The link.
the link.
Okay. Okay.
Yes,
No
yes.
problem. Thank you so much.
Welcome, Mr. Chobi. Apologies for that. Apologies. So okay. So let me end the recording, then send the link immediately. Thank you guys.